I've been doing this for 31 years. Lawrence Pruitt's voice filled courtroom 4 before he even reached his table. 31 years, and today they send me 2 black girls with a folder from the dollar store. He laughed. Not a quiet laugh, the kind that expects the room to follow. Then he picked up the twins' document folder, looked at it once, and dropped it off the edge of the defendant's table. Papers scattered across the floor like he'd been waiting all morning for the chance. "Go home," he said without turning around. "Help your grandfather pack his things and let the adults finish this." He turned to his associates and dropped his voice just enough to still carry across the aisle. "I've seen better legal arguments written on a fast food receipt." One associate smiled. The other looked down. Pruitt straightened his jacket, sat down, and looked directly at Destiny, not both of them, just Destiny, and said it quietly, almost gently, the way cruelty sounds after 30 years of practice. "Sweetheart, your grandfather already lost this land. You two just haven't accepted it yet." Diamond picked up every page from the floor, one by one, face empty. Destiny never moved, hands flat on the table, eyes forward. Raymond Tate sat 3 rows back, oxygen tube under his nose, hands folded, watching. Nobody in that room knew it yet. But one of those pages Diamond just picked up contained a single timestamp that would end Lawrence Pruitt's career before lunch. Don't go anywhere. Drop your city and local time in the comments. Right now, I want to know where in the world people are still hungry for justice. And if you're new here, subscribe. You'll want to see how this ends. Calhoun Parish, Louisiana. A place where the Spanish moss hangs so thick on the old oaks that it blocks the afternoon sun, and where certain last names have opened every door in the parish for the better part of a century. The Pruitts, the Fontenauds, the Delacroix family, who still own the cotton gin that hasn't run since 1987, but whose name sits on the elementary school, the public pool, and the courthouse annex. In Calhoun Parish, old money doesn't just talk. It decides who gets to talk back. Pinewood Road runs along the eastern edge of town, where the land flattens out, and the pine trees grow close together, and the soil turns dark red after a heavy rain. It isn't the kind of street that appears on real estate listings or in the parish's tourism brochures. It's the kind of street where people have lived for generations without anyone from the other side of town paying much attention until recently. Raymond Tate bought his 4.2 acres on Pinewood Road in 1961. He was 23 years old. He had been working the Calhoun lumber mill since he was 15, 6 days a week, 10 hours a day, the kind of work that takes something out of a man every single morning and doesn't give it back. For 9 years, he saved every dollar he could pull away from rent and food and the occasional bus fare into town. He kept the money in a coffee tin under the floorboard of his rented room on the south side of the parish. Not in a bank, because in 1955 in Calhoun Parish, a black man's money had a way of disappearing from bank accounts in ways that were never quite explained and never quite investigated. In the spring of 1961, he walked into the parish land office with $3,200 in cash money. He had counted and recounted so many times the bills had gone soft at the edges, and he bought the land outright. No mortgage, no payment plan, no white cosigner standing beside him to make the paperwork acceptable. He paid in full, and he walked out with a deed in his name, and he went home and sat on the ground under the pine trees for an hour before he could stand up again. He built the house himself the following year. 4 rooms, a wide front porch, a kitchen window that faced east, so the morning light came in while he made coffee. He planted a vegetable garden along the south fence line. Tomatoes, pole beans, collard greens. The same things his mother had grown in the yard of the house she rented her entire life and never owned. Raymond raised his daughter Loretta on that land. Loretta grew up on that porch, went to school in that parish, came back after college, and married a man named Curtis Tate, who was good and steady and worked the overnight shift at the Calhoun water treatment plant. They moved into the house on Pinewood Road because Raymond had added 2 rooms by then, and because the land was paid for, and because there was something about a paid-for piece of land in Louisiana that felt like the safest place in the world to raise children. Destiny and Diamond were born on a Tuesday in March 19 years ago. Twin girls, 4 minutes apart, Destiny first, Diamond second. A fact Diamond has disputed her entire life on the grounds that the hospital clock was running slow. They were 6 years old when the accident happened. Curtis was driving home from his overnight shift on a Wednesday morning in early December. Fog on Route 9, the kind that sits low and thick and makes the road disappear 10 feet in front of your headlights. A drunk driver crossed the center line at 6:14 in the morning and hit Curtis's car head-on. Loretta was in the passenger seat. She had ridden along because they were going to stop for breakfast at the diner on the way home, a Wednesday tradition they'd had since before the girls were born. Neither of them made it to the hospital. Raymond was 65 years old when he became the sole guardian of 2 6-year-old girls. He was arthritic in both knees. He had a mild heart condition his doctor had been watching for 2 years. He was still grieving his daughter in the way a parent grieves, not loudly, not publicly, but in the quiet spaces of the morning before the girls woke up, sitting at the kitchen table with his coffee going cold and the eastern light coming through the window. He raised them anyway. He packed their lunches every morning until they were old enough to do it themselves. He went to every parent-teacher conference, every school play, every science fair. He retired from the Postal Service at 70 after 34 years of delivering mail on the same route through the same streets of Calhoun Parish streets he had walked during the civil rights marches of the 60s, delivering letters to people on both sides of that history without ever missing a day. The parish knew Raymond Tate. The black community on Pinewood Road knew him as the man who had always been there, steady and present and unbothered by the slow erosion of everything around him. In the summer of 2021, the stroke came without warning. He was in the garden when it happened, right there among the tomatoes on the same soil he had bought 60 years earlier. The paralysis settled permanently in his right hand. The doctors were direct about it. The function was gone, and it was not coming back. He was 75 years old, and he learned to write with his left hand the way a man learns anything late in life, slowly, stubbornly, with more determination than grace. His new signature was uneven. The letters leaned forward. The pen skipped when his grip weakened. Nothing like the smooth, controlled, right-handed signature on the deed transfer that arrived in his mailbox on a Tuesday afternoon in October. A deed that claimed Raymond Tate had voluntarily signed over 4.2 acres on Pinewood Road to Calhoun Development Partners in April of 2022. 10 months after his right hand stopped working, Raymond held the letter in his left hand and read it twice. Then he set it on the kitchen table and looked out the window at the pine trees and said nothing for a long time. When Destiny came home from her shift at the grocery store that evening and found him sitting there in the dark, she turned on the kitchen light and saw his face. She picked up the letter. She read it once, and something settled in her chest, not panic, not grief, something harder than both of those things. She went to her room, opened the blue composition notebook on her desk, and started writing. Calhoun Development Partners had been buying up Pinewood Road for 3 years. Not quickly, not loudly. The way water gets into a foundation, slowly, patiently through the smallest available opening, until one morning you look down and the floor is soft and the damage is done. It started with the Morrow family at the north end of the road. Eugene Morrow, 71 years old, had owned his 1.8 acres since 1978. In the spring of 2020, he received a letter informing him that CDP was disputing the eastern boundary of his property based on a survey he had never commissioned. The lawsuit that followed cost him $4,200 in legal fees before his attorney told him quietly that fighting Calhoun Development Partners in Calhoun Parish Court was not a battle he was likely to win. Eugene sold for $18,000. His land had been appraised at $47,000 the previous year. The Robinsons went next. Then the Washington family. Then the Thibodeau sisters, who had inherited their parents' land jointly and couldn't agree on whether to fight. And while they disagreed, CDP filed an injunction that froze the property and drained both of them in legal fees until there was nothing left to disagree about. 4 families, 4 parcels, gone in 3 years. Raymond Tate's 4.2 acres sat between CDP's 2 largest acquisitions on Pinewood Road like a single brick in a wall they were trying to knock down. Without it, their planned riverfront luxury development, Pinewood Reserve as the renderings called it, 48 units starting at $680,000, could not connect its northern and southern parcels into a single buildable lot. Raymond's land wasn't just valuable to them. It was necessary. Lawrence Pruitt had handled all 4 previous acquisitions. 31 years of Calhoun Parish real estate litigation. His office occupied the entire 2nd floor of the First Parish Bank building on Court Street, with his name on the directory in the lobby in brass letters, Pruitt Law Group Real Estate and Land Transactions. The kind of office that tells you the man inside charges more per hour than most people on Pinewood Road earn in a week. He had never lost a land case in Calhoun Parish, not once. The certified letter arrived on a Tuesday. The lawsuit claimed Raymond had signed a deed transfer in April 2022 conveying full title of the Pinewood Road property to Calhoun Development Partners. The document included a notarized copy of the deed with Raymond's signature at the bottom, smooth-controlled, written with the steady hand of a man who had full use of both of his. Raymond Tate had not had full use of his right hand since July of 2021. 2 days after the letter arrived, a white pickup truck pulled onto the dirt driveway on Pinewood Road. 2 men got out. Khaki pants, polo shirts, clipboards. They walked the property line with a measuring tape without knocking on the door or announcing themselves. Raymond was in the garden when they arrived. He was on his knees between the tomato rows, his left hand working the soil around the base of a plant, when he heard the truck door slam. He looked up. One of the men walked directly toward the south fence line and began measuring. The other took photographs, the house, the porch, the garden, the tree line. Raymond stood slowly, knees aching. "Can I help you?" The man with the camera turned, looked at Raymond the way you look at an inconvenience. "Property survey, ordered by the new owners." "There are no new owners," Raymond said. "This is my land." The man looked at his clipboard, looked back at Raymond, and said it without any particular emotion. The way a man says something he has said many times before and stopped thinking about years ago. "Sir, we're just doing our job. This property is listed as abandoned in our records. You'll want to take that up with the court." Abandoned. Raymond was standing in his own garden. The garden he had planted and tended for 60 years. The garden where his daughter had learned the names of vegetables before she learned to read. The garden where his granddaughters had shelled butterbeans on summer evenings, while he told them stories about the parish before they were born. Abandoned. He didn't answer. He stood very still and watched the 2 men complete their survey, walk back to their truck, and drive away without closing the gate behind them. That night, Raymond's oxygen levels dropped to 81%. Destiny drove him to Calhoun General at 11:30. The attending physician used the words stress-induced and kept him overnight for observation. Destiny sat in the waiting room under fluorescent lights until 2 in the morning, a paper cup of cold coffee in her hand and the blue composition notebook open on her knee. She wasn't writing case notes. She was writing down everything those 2 men had said. Every word. The way they said it. The way Raymond had looked standing in his garden, while a stranger called his land abandoned to his face. She wrote it all down because she had learned early that the details matter. That the specific word a person chooses tells you everything about what they actually believe. And what that man believed, what CDP believed, what Lawrence Pruitt believed, was that Raymond Tate was already gone, that the land was already theirs, that this was already over. Diamond arrived at the hospital at midnight with a change of clothes for Destiny and a printed copy of Louisiana Code of Civil Procedure, Article 734. "I found something," she said, sitting down beside her sister. Destiny looked at the page. Diamond tapped a paragraph near the bottom. "Louisiana doesn't require licensed counsel for civil property defense. If Grandpa gives us power of attorney, we can represent him ourselves." The waiting room was empty, except for the two of them. The fluorescent light above them hummed. Destiny closed her notebook. "Then that's what we're going to do," she said. Destiny started making calls the morning after Raymond came home from the hospital. She sat at the kitchen table at 7:15, with her composition notebook open, a handwritten list of 12 law firms in front of her, and Raymond's cordless phone beside her coffee. She had spent the previous night in the hospital waiting room researching every property law attorney within 3 parishes. She had their names, their firm sizes, their advertised specialties, and in 2 cases, their recent case histories pulled from the public court docket. She was prepared. She had always been prepared. Preparation was the thing she had learned to rely on when everything else was uncertain. Firm number 1 picked up on the second ring. A receptionist with a pleasant voice listened to the first 40 seconds of Destiny's explanation and then said carefully, "I'm sorry, we have a prior relationship with Calhoun Development Partners. We wouldn't be able to take on anything adverse to their interests. Conflict of interest." Destiny wrote it in her notebook. Drew a line through the firm's name. Firm number 2 said the same thing. Different words, same answer. Firm number 3 said it faster than the others, like the receptionist had been trained to recognize the situation immediately. "Ma'am, if this involves CDP and Lawrence Pruitt, we're not in a position to help you." 3 calls, 3 closed doors. Destiny kept dialing. Firm 4 quoted a retainer of $7,500 just to review the paperwork. Firm 5 wanted $9,000 and couldn't begin for 3 weeks, which was 1 week after the court date. Firm 6 said $6,200 and listed 14 items they would need before they could assess viability. Destiny looked at the bank statement Raymond had left on the table that morning. His savings account showed $980. His monthly postal pension covered his mortgage, his utilities, his medication, and not much else. She wrote the numbers down in her notebook. $7,500, $9,000, $6,200, $980. The math was not complicated. The math was the point. Firm 7 was different. A man answered, not a receptionist, the attorney himself, which surprised her. She got through the whole story: the deed, the forged signature, the paralyzed hand, the court date. He listened without interrupting, which she took as a good sign. When she finished, there was a pause. Then he said, "Honey, even if I took this case for free, you'd still lose. Lawrence Pruitt has owned every judge in this parish for 20 years. Another pause shorter. "Save your grandfather the embarrassment." The line went dead. Destiny set the phone down on the table. She sat very still for a moment. Then she picked up her pen and wrote the firm's name in her notebook, with a single word beside it, coward. She underlined it once. Then she kept going. Firm 8 didn't answer. She left a voicemail that was never returned. Firm 9 answered, listened, and said they were at capacity. Firm 10 was in the neighboring parish, 40 minutes away. The paralegal who answered sounded young and genuinely sorry. She asked Destiny to hold while she checked with the senior partners. Destiny held for 7 minutes. The paralegal came back and said, in a voice that had changed, "I'm really sorry. We just can't." Firm 11 voicemail. Firm 12, a different conflict of interest. They represented a company that did surveying work for CDP. Not directly adverse, but close enough that the partner didn't want the exposure. 12 calls, 12 doors, all of them shut. Diamond tried a different route. She found the Louisiana Civil Justice Legal Aid Coalition online and submitted an emergency application that same afternoon, attaching the deed, the medical records confirming Raymond's paralysis, and a written summary of the case. The application took her 3 hours to complete. She checked every box. She uploaded every document. The automated response arrived the following morning. "Thank you for your application. Due to current caseload and staffing limitations, our estimated wait time for new property defense cases is approximately 4 to 5 months. If your matter is time-sensitive, we recommend seeking private counsel." 4 to 5 months. The court date was in 22 days. That afternoon, Diamond was in the living room when she heard a knock at the front door. She looked through the window before opening it. A man she didn't recognize stood on the porch, mid-30s, white khaki pants, a collared shirt with a small CDP logo embroidered above the pocket. He was holding an envelope. Diamond opened the door, but not the screen. The man smiled. "Is Mr. Tate available?" "He's resting," Diamond said. "What do you need?" The man held out the envelope. "I just need to deliver this personally. It's a formal offer from Calhoun Development Partners." Diamond took it. She opened it at the kitchen table with Destiny standing beside her. Inside was a check for $14,000 made out to Raymond Tate. A cover letter explained that CDP, in a gesture of goodwill given the pending litigation, was offering to purchase the property at what the letter described as fair market value and to withdraw the lawsuit upon acceptance. Destiny looked at Diamond. The proposed resort would start at $680,000 per unit. 48 units. CDP was offering Raymond $14,000 for the land that made the entire project possible. Raymond came into the kitchen as Diamond was reading the cover letter aloud. He listened. Then he took the check from the table, looked at it for a moment, and dropped it on the floor. The man was still on the porch. Destiny opened the front door. He was already stepping off the porch. He turned, reached into his shirt pocket, and set a business card on the porch railing without coming back up the steps. "The offer expires when the judge calls your name," he said. Then he walked to his car and left. Destiny picked up the business card. She held it for a moment. Then she went back inside, sat down at the kitchen table, opened her blue composition notebook to a fresh page, and wrote 3 words at the top. "We do this ourselves." The Calhoun Parish Public Library opened at 7 in the morning. Destiny was there at 6:55. She came back every day for the next 22 days. Same entrance. Same corner table by the window, third from the left, where the morning light came in at an angle that didn't hit the page directly, and where she could see the door without turning around. She brought her composition notebook, a mechanical pencil, and a thermos of coffee Raymond made for her before she left, each morning quietly, without being asked, the way he had made her lunch every school day for 13 years. The library's law section occupied half a shelf on the second floor. Louisiana Civil Code. Title 9 Property. Title 35 Notaries Public. She pulled every volume that touched land transactions and read them, the way she read everything slowly, completely taking notes in the margins of her notebook, following every citation to its source, every statute to its exception. On the 3rd day, the librarian noticed her. Mr. Eugene Batiste was 64 years old, semi-retired, working 3 days a week, because as he told anyone who asked, He didn't know what he would do with himself otherwise. He had worked in the Calhoun Parish Library system for 31 years. He had watched a lot of people sit at a lot of tables, and he had developed over those decades a reliable instinct for the difference between someone killing time and someone fighting for it. He watched Destiny for 2 full days before he did anything. On the third morning, he walked past her table, set a volume down without breaking stride, and kept walking. A sticky note on the cover read, Title 9. Start there. E.B. It was exactly the volume she needed and hadn't found yet. She looked up, but he was already at the circulation desk with his back to her. She opened the book. It was the only outside help either of them received in 22 days. Diamond worked from home. The family's desktop computer was 7 years old and took 4 minutes to boot, and it crashed if she opened more than 5 browser tabs simultaneously, which meant she had developed a system, one tab for the Louisiana Secretary of State database, one for the parish clerk's property records, one for the court's electronic docket, and one spare she used carefully. She kept a legal pad beside the keyboard and wrote everything down by hand as backup because she had learned not to trust a machine that crashed without warning. She built the evidence wall in Raymond's living room. Blue and yellow sticky notes, red string, a timeline running left to right across the wall above the television, dates on the top line, names below, connections drawn in red ink between related points. Raymond watched her work on it one evening from his chair oxygen tank humming beside him and said nothing for a long time. Then he said, "Your grandmother used to make quilts, laid the pieces out on the floor, first figured out the pattern before she sewed a single stitch." He looked at the wall. Same thing. Diamond didn't answer. She was tracing a line in red ink between 2 dates. The key detail was there from the beginning, buried in the document CDP had filed with the court. The deed transfer was dated April 14th, 2022. The signature at the bottom, Raymond Tate in full, was smooth and controlled the letters upright and evenly spaced the pen pressure, consistent from start to finish. The signature of a man with full confident use of his dominant hand, Raymond's right hand, the hand that had been permanently paralyzed since July of 2021, 9 months before the deed was supposedly signed. Destiny had seen it on the first night reading the deed at the kitchen table. She had written it in her notebook immediately. Signature right-handed post-stroke. Impossible. But she had kept reading, kept pulling threads, kept looking for everything else that was wrong, because she knew that one detail, however compelling, was not enough on its own. A good attorney could argue partial recovery. A good attorney could argue the medical record was incomplete. A good attorney could argue anything for long enough to confuse a courtroom. She needed more. Diamond found it. It was a Tuesday night, 11 days before the hearing. Diamond was alone in the living room, the evidence wall glowing faintly in the light from the desk lamp, when she opened the Louisiana Secretary of State's notary public database and typed in the name from the deed, Carol Ann Pruitt. The record loaded in 4 seconds. Commission status active. Diamond stared at the screen. Active. She wrote it down. Then she kept reading, and at the bottom of the record, under the Commission History tab, she found a secondary notation she almost missed. A cross-reference to a public malpractice proceeding filed in Calhoun Parish District Court in the fall of 2022. She clicked the link. The malpractice filing contained hospital admission records submitted as exhibits. Carol Ann Pruitt, Calhoun General Hospital. Admitted April 9th, 2022. Medically induced coma following emergency surgery. Discharged April 29th, 2022. Diamond read it again. April 9th to April 29th. The deed was dated April 14th. Carol Ann Pruitt had been in a medically induced coma on the day she supposedly notarized Raymond Tate's signature. Diamond's hand went cold on the mouse. She didn't move for a moment. Then she reached over, hit print, and listened to the old printer in the corner groan and shudder and pull the page through. She picked up the page, read it a third time. Then she walked to the kitchen doorway. Destiny. Destiny appeared at the top of the stairs. Diamond held up the page. She didn't say anything else. She didn't need to. Destiny came downstairs, read it standing at the kitchen counter, and set it down. Outside, the pine trees on Pinewood Road stood dark and still against the night sky. The same trees Raymond had sat under in 1961, with a deed in his hand and 60 years of his life still ahead of him. "How do we prove the signature?" Diamond said. Destiny was already climbing the stairs. "I know exactly how," she said. "Come up, I need to show you something I found 3 days ago." Destiny's room looked nothing like a teenager's room anymore. The desk had been cleared of everything except the composition notebook. A second notebook she had bought at the dollar store when the first one filled up, and a manila folder thick with printed documents organized by date. The floor beside the desk had 3 stacks of paper medical records on the left, property filings in the middle, notary law on the right, each held together with a binder clip and labeled in her handwriting. She had not slept more than 4 hours in any single night since the letter arrived. She laid 2 documents side by side on the desk. On the left, the deed transfer, April 14th, 2022. Raymond Tate's signature at the bottom, smooth right-leaning, every letter fully formed, the pen never lifting between strokes. On the right, Raymond's power of attorney form, signed 3 days ago with his left hand. The letters uneven, the baseline wandering. The pen had skipped twice where his grip lost pressure mid-stroke. The signature of a man learning to write again at 75, retraining his hand to do something it had never been asked to do. 2 signatures, same name, different hands, different years, different everything. "The deed signature is right-handed," Destiny said. "Clean, consistent pressure, slight, rightward lean. That's dominant handwriting, his right hand." She tapped the power of attorney. "This is his left. You can see where the pen skips, his grip strength on the left isn't full yet. The baseline drifts." She looked at Diamond. "No stroke recovery produces this. You don't go from this." She pointed to the power of attorney. "Back to this." She pointed to the deed. "Not in the same direction. Not with the same pressure. The neurological pathway is gone." Diamond looked at both pages. "Can we prove that without a medical expert? We have his hospital records. Complete paralysis, right side, permanent notation. The doctor's language is unambiguous." Destiny opened the manila folder. "And we have this." She pulled out a printed page, Raymond's discharge summary from Calhoun General, July 2021. The attending physician's notes used the words permanent and non-recoverable twice each. The physical therapy assessment from the following month said the same thing in different language. "Pruitt will argue partial recovery," Diamond said. "Let him argue it," Destiny said. "He'll be arguing it against his own notary's hospital records. They worked until 2 in the morning." Diamond cross-referenced the malpractice filing exhibits against the deed timeline 3 separate times to confirm the dates were not a scanning error or a clerical transposition. They were not. Carol Ann Pruitt had been admitted to Calhoun General on April 9, 2022, following emergency abdominal surgery that led to septic complications. The medically induced coma was documented in the attending physician's daily notes, available as public exhibits in the malpractice proceeding. She was not discharged until April 29th. The deed bore her notary stamp, and her signature dated April 14th. 5 days into a medically induced coma. Diamond printed the relevant pages from the malpractice filing. The old printer jammed twice and she had to clear the paper feed with a letter opener. By the time she had clean copies of everything she needed, it was nearly 2:30. She brought the pages downstairs and added them to the evidence wall, drew a new red line, labeled it in block letters, Notary in coma, April 14th. In coma, April. Then she sat down on the living room floor and looked at the wall. The whole shape of it was visible now, not complicated once you could see it. A deed that couldn't have been signed by the man whose name was on it. A notarization that couldn't have been performed by the woman whose seal was on it. Two impossibilities stacked on top of each other and filed with the court, as though neither one would ever be checked. Because nobody had expected anyone to check. The following morning, Calvin Webb came by. Calvin was 67 years old, lived 4 houses down, had known Raymond since before the twins were born. He was a big man, soft-spoken, worked part-time at the auto parts store on Route 12. He brought a container of red beans and rice and set it on the kitchen counter without being asked. He sat down at the table with Raymond and the twins and listened to Destiny walk through everything they had found. He didn't interrupt. When she finished, he was quiet for a moment. "Same thing happened to Eugene Morrow," he said. "Different notary, but same setup. Deed showed up with a signature Eugene swore he never made." He looked at his hands. "Eugene didn't have what you two have, though. He didn't know where to look." He paused. "Raymond started at the mill right after Korea," he said. "Toughest man I ever knew. Built half of what's on this road with his own hands." He looked at Destiny. "You find what you need to find." "Almost," Destiny said. That night, 11 hours before the hearing, Destiny was at the kitchen table at 11:40 when she opened the court's electronic docket one final time to review the filing timeline. She almost missed it. A new entry, time-stamped 6:02 a.m., that morning filed before the courthouse was open to the public, submitted through the attorney portal. An amended deed, filed by Lawrence Pruitt. She clicked on it. The amendment changed 2 things. The recorded acreage figure from 4.2 acres to 3.9 acres and the parcel identification number in the property description. Small adjustments. The kind of changes that looked administrative. The kind of changes that would take 30 seconds to notice and 30 minutes to explain. Destiny stared at the screen. If the deed were real, if it had been genuinely signed by Raymond Tate in April of 2022, there would be no reason to amend it the morning of the hearing. The numbers would have been right. They would have matched the county records. There would have been nothing to fix. Pruitt had amended the deed because he knew the original wouldn't survive the day. Destiny opened her notebook to the last clean page. She wrote 1 sentence. Slowly, carefully, the way she wrote everything that mattered. She looked at it for a long time. Then she closed the notebook, put it in her bag, and went upstairs to tell Diamond it was time to sleep. They had 3 hours before they needed to be dressed. They had everything they needed. The Calhoun Parish Courthouse was built in 1923. The exterior was grand in the way that small-town courthouses from that era were grand. Tall white columns, wide stone steps, the parish seal carved above the entrance in limestone that had gone gray with a century of Louisiana humidity. Inside courtroom 4 was a different story. The ceiling tiles had water stains in the corners. One of the overhead fluorescent panels flickered with a rhythm so consistent it had probably been flickering for years, and nobody had filed a maintenance request. The air conditioning unit in the east wall rattled when it cycled on and produced a sound like a shopping cart being dragged across gravel. The room smelled like floor wax and old wood, and something underneath both of those things, the specific smell of a place where difficult things have been decided for a long time. Destiny noticed all of it when she walked in. She noticed it the way she noticed everything cataloged. It filed it. used it to understand the room she was walking into. Small courtroom, low ceiling, gallery seating for maybe 40 people, a judge's bench that sat elevated just enough to change the angle of every conversation that happened beneath it. A room designed to remind you, without saying it directly, that some people in it had more standing than others. Lawrence Pruitt was already seated at the plaintiff's table when the twins arrived. Charcoal suit pressed so sharp the lapels could cut paper. A monogrammed briefcase in dark brown leather, the kind that costs more than Raymond's monthly pension. Two junior associates flanked him, both in navy blue, both with matching yellow legal pads, both arranged with the posture of men who understood that their job today was to look credible by proximity. Pruitt didn't look up when Destiny and Diamond entered. He was reviewing a document with the focused disinterest of a man who had already won and was simply waiting for the paperwork to confirm it. The defendant's table had 2 manila folders and a blue composition notebook. They sat down. Behind them, the gallery door opened. Calvin Webb came in first, still in his work clothes. Gray postal uniform, pants, heavy boots, a dark green jacket he wore every Sunday to church, and apparently to courtrooms as well. He took the second row and nodded at the twins' backs without saying anything. 2 other Pinewood Road residents came in after him and sat quietly. Then a man Destiny didn't recognize entered from the main gallery door and took a seat in the back corner. Late 40s, dark green jacket, different shade than Calvin's small spiral notepad, visible in his breast pocket. He sat down, crossed one ankle over his knee, and looked at the room the way a person looks at something they've been sent to observe. Nobody knew who he was yet. Raymond came in last, pushed by a volunteer from the hospital's outpatient program who had driven him over. Oxygen tube in place, hands folded in his lap. He rolled to a stop in the open space beside the second row and looked at his granddaughters' backs for a moment. Then he looked at Lawrence Pruitt. Then he looked at the judge's empty bench. He had been in this courthouse before. 40 years ago, applying for a property tax exemption, he was entitled to and had to apply for 3 times before it was granted. He remembered the smell. The side door opened. All rise. The Honorable Judge Margaret Fontenot presiding. Judge Fontenot entered at exactly 9 o'clock. 61 years old, silver hair pulled back without ornament, reading glasses on a chain around her neck. She sat, opened her folder, scanned the room, once the efficient, comprehensive scan of a woman who had been reading courtrooms for 27 years, and sat down. Be seated. She looked at her docket. Case number 23-4471, Calhoun Development Partners versus Raymond Arthur Tate. Mr. Pruitt, you may proceed. Pruitt rose, buttoned his jacket. The gesture of a man who had done this so many times it was reflex. Thank you, Your Honor. This is a straightforward matter of recorded title. My client, Calhoun Development Partners, holds a valid and notarized deed transfer executed by the defendant in April of 2022. The property, 4.2 acres on Pinewood Road, was legally and voluntarily conveyed. We are asking the court to enforce what the record already reflects. He paused. I expect this will require no more than 20 minutes of the court's time. He sat. Fontenot looked at the defendant's table. Does the defendant have counsel present? Destiny stood. Her chair scraped the floor loud in the quiet room. She had rehearsed the sound of it in her head 100 times, and it was still louder than she expected. Your Honor, my name is Destiny Tate. This is my sister Diamond Tate. We are representing our grandfather Raymond Arthur Tate under a signed and notarized power of attorney filed with this court on October 14th. Pruitt turned his head slowly. The expression on his face was the same one he'd worn in the gallery that morning, not anger, not surprise, something more comfortable than both of those things. Amusement worn smooth by decades of use. Your Honor. His voice carried the patience of a man explaining something obvious to someone who should have figured it out already. Are we genuinely proceeding like this? I have a 31-year litigation record in this parish. The individuals across the aisle are 19 years old. With respect, this is not a high school mock trial. Someone in the gallery made a sound that wasn't quite a laugh. Fontenot did not smile. She looked at Destiny over the top of her reading glasses. Ms. Tate, do you understand the nature and procedural requirements of these proceedings? Yes, Your Honor. Destiny's voice was steady. This is a civil action for property possession filed under Louisiana Civil Code Article 2439. The burden of proof rests with the plaintiff to establish valid title by authentic act. We intend to demonstrate that the deed presented by Mr. Pruitt is void as a matter of law. The room shifted, not a sound, a feeling. The way a room changes when something unexpected has just been said clearly and without apology, and everyone present has understood it at the same moment. Fontenot's pen paused on her notepad. She looked at Destiny for 1 full second longer than she had looked at anyone else in the room. Proceed, Mr. Pruitt, she said. Pruitt's amusement thinned. Just slightly. Just enough. He introduced the deed. Clean photocopy projected on the wall screen. Raymond Arthur Tate, April 14th, 2022. Notarized by Carol Ann Pruitt. Recorded in the parish clerk's office. The document speaks for itself, Your Honor. Signed, notarized, recorded. I fail to see what remains to contest. Destiny stood. Your Honor, may I examine the original document? Pruitt hesitated. 1 second. 2. Then he handed it across the aisle without standing up, the way you hand something to a person you've already decided doesn't matter. Destiny held it, looked at it carefully, set it down, picked up her pen and wrote 1 line in her notebook. Then she looked up. Your Honor, I'd like to enter Exhibit A into evidence. And she placed the hospital records on the table and began to speak. Her voice did not waver, it did not rise, it did not perform. And in the back row, the man in the dark green jacket opened his spiral notepad for the first time and began to write. Destiny laid Exhibit A on the table with both hands. Calhoun General Hospital. Discharge Summary, July 2021. Attending physician's notation, repeated twice in the document. Permanent paralysis, right upper extremity, non-recoverable. Physical therapy assessment, August 2021. Patient demonstrates complete absence of voluntary motor function in right hand and forearm. Prognosis unchanged. She read the key line aloud, without inflection, the way you read something that doesn't need help to land. Your Honor, the signature on the deed presented by Mr. Pruitt was made by a right hand. Our grandfather has not had use of his right hand since July of 2021. The deed is dated April of 2022, 9 months after permanent paralysis was documented by his treating physician. She set the discharge summary beside the deed on the table, 2 documents, side by side. The room was quiet enough to hear the fluorescent panel flickering in the back corner. Pruitt was on his feet before she finished the last sentence. Objection, Your Honor. Stroke recovery is not linear. Many patients experience partial or significant return of function over time. The defense is presenting a single discharge summary as though it forecloses all possibility of recovery, which is medically inaccurate and legally irrelevant, without expert testimony to establish a direct causal link. He straightened his jacket, straightened his Halmos-hund. A hospital record from 9 months prior does not prove what a man's hand could or could not do on a specific date in April. I could produce a hospital record showing I broke my wrist in 2019. That doesn't mean I couldn't sign a document in 2022. He sat. His associates were both writing. One of them slid a note across the table. Pruitt read it and set it aside without expression. Fontenot looked at Destiny. Response. Your Honor, the discharge summary is supported by the physical therapy assessment from the following month, which I have also entered as part of Exhibit A, and which uses identical language, complete absence of voluntary motor function prognosis unchanged. We are not relying on a single document. Destiny paused one beat. But the court does not need to resolve the medical question to rule on this deed, because the deed has a second problem that is not a matter of interpretation. Fontenot's pen stopped. She looked at Destiny over her reading glasses. Your Honor, I'd like to enter Exhibit B. Diamond stood for the first time. The room turned. Every head. Pruitt's eyes moved to her with the particular attention of a man recalibrating. He had been focused on. Destiny had mapped her rhythms, had prepared responses to her arguments. Diamond had been invisible to him until this moment. That had been the point. Diamond's voice was quieter than her sister's. It carried anyway. Your Honor, Exhibit B consists of 2 documents. The first is a certified printout from the Louisiana Secretary of State's Notary Public Database showing that the deed's notarization was performed by Carol Ann Pruitt, Commission Number 74-2281, Calhoun Parish. She set the page on the table. The second document is a set of hospital admission and discharge records from Calhoun General, submitted as public exhibits in a malpractice proceeding, filed in this courthouse in September of 2022. She set the second document beside the first. She set the second. Carol Ann Pruitt was admitted to Calhoun General on April 9, 2022, following emergency surgery that resulted in septic complications. She was placed in a medically induced coma on April 10th. She was not discharged until April 29th. Diamond looked up from the page. The deed was notarized on April 14, 2022, 5 days into her coma. She folded her hands. Under Louisiana Revised Statute 3514, a notarial act performed by an individual who lacks legal capacity at the time of execution is void. Carol Ann Pruitt was in a medically induced coma. She had no legal capacity. She had no physical capacity. She was unconscious in a hospital bed in this parish on the day her name and seal appear on this document. The gallery did not make a sound. Calvin Webb's hands were pressed flat against his knees. His jaw was set. Beside him, one of the Pinewood Road residents had leaned forward with both elbows on the row in front of her, staring at the plaintiff's table. Pruitt stood. Objection. Those hospital records are not properly authenticated for use in this proceeding. They were filed as exhibits in a separate malpractice case and cannot simply be transplanted into this action without. They were filed and accepted in a public proceeding in this courthouse, Mr. Pruitt, Fontenot said. Her voice was level and absolute. By this court. They carry the authentication of this court's own record. She looked at him over her glasses. Overruled. Sit down. Pruitt sat. For the first time since the hearing began, he did not immediately pick up his pen. Fontenot announced a 25-minute recess. The side door had not fully closed behind the judge before Pruitt was on his phone. He walked to the far corner of the hallway back to the wall and spoke in a voice low enough that the words were indistinct, but the tone was not. Tight. Controlled. The tone of a man who is not panicking because he has trained himself not to panic, but who is doing the thing that comes just before it. In the hallway outside Courtroom 4, Destiny leaned against the wall beside the water fountain. Her hands were in her pockets. Diamond stood next to her. You're shaking, Diamond said quietly. I know. You don't look it. Destiny didn't answer. She was looking at the courthouse floor, old tile worn pale in the center of the hallway, where decades of feet had passed over it. Then one of Pruitt's associates came through the door. Not Pruitt. The associate, younger mid-30s, the one who had been writing notes all morning. He walked toward the water fountain, filled a paper cup, and turned to Diamond as though the movement were incidental. "You should think carefully," he said without looking at her directly, his voice just above a murmur, "about what happens to your grandfather's medical coverage if this goes sideways. Stress is hard on old men." He dropped the paper cup in the trash and walked back through the door. Diamond stood completely still for 3 seconds. Then she turned to Destiny. Her face was composed. Her voice was steady. "Write that down," she said. "Exact words. Right now." Destiny already had her notebook open. Raymond wheeled through the door from the gallery side. He looked at both of them, took one of each of their hands in his left hand. "I know what you're carrying," he said. "You've been carrying it since you were 6 years old. I watched you pick it up, and I never found a way to put it down for you." His voice was even. "I'm sorry for that. And I'm proud of you, both of you, whatever happens in that room." Destiny closed her notebook. She had one thing left. When court resumed, Lawrence Pruitt looked different, not broken, not afraid, but different in the way a machine looks different when something inside it has shifted, still running, still producing the right sounds, but with a new vibration underneath everything that wasn't there before. His jacket was rebuttoned. His posture was correct. But the associate who had been writing notes all morning had stopped writing, and the other one had quietly moved his legal pad to the side of the table, as though he no longer expected to fill it. Pruitt opened with an attack. It was the right tactical decision given what he had left. You cannot defend a notary who was in a coma. You cannot explain a signature written by a hand that stopped working 9 months before the document was dated. What you can do if you are Lawrence Pruitt, and you have 31 years of Calhoun Parish courtrooms behind you, is make the room question the people who found those things. Your Honor, before we continue, I need to place something on the record. He stood with both hands resting on the plaintiff's table, relaxed, deliberate. The individuals representing the defendant have no legal training, no bar admission, no professional credentials of any kind. They are 19 years old. He let the number sit in the air for a moment. What we have witnessed this morning is not legal argument. It is amateur research, the kind of document gathering that any person with internet access and sufficient motivation could produce. I would urge this court to weigh it accordingly. He sat. It was smoothly done. It would have worked on a different judge or a different day. It was the argument that had probably ended a dozen cases before they reached this point, not by addressing the evidence, but by diminishing the people who found it. Fontenot removed her reading glasses. "Mr. Pruitt?" Her voice was not loud. It did not need to be. "The respondents hold a valid notarized power of attorney filed with this court. They have standing. The evidence they have presented consists of certified medical records and documents filed in public proceedings in this courthouse. I will not hear another word about their ages or their educational backgrounds." She put her glasses back on. "Continue." Pruitt's jaw tightened. One of his associates looked at the table. Fontenot turned to the defendant's side. "Ms. Tate, do you have anything further?" Destiny stood. She picked up her blue composition notebook. She did not open it. She stepped around the end of the defendant's table, not toward Pruitt, not toward the bench, just forward into the open space between the two tables where the room could see her clearly. She was wearing a white button-down shirt that was slightly too large in the shoulders. Her shoes were polished. Her hands were steady. She looked at Lawrence Pruitt. "Mr. Pruitt," she said. He looked up. His expression said, "Go ahead. If this deed is authentic, if it is the valid, complete, and accurately recorded document you have represented to this court, then why did you file an amended version of it at 6:02 this morning, 2 hours before this hearing began?" Silence. Not quiet. Silence. The particular silence of a room in which something has just been said that cannot be unsaid, and everyone present knows it simultaneously. The fluorescent panel in the back corner flickered once and held. Calvin Webb did not move. The woman beside him had both hands pressed over her mouth. In the back row, the man in the dark green jacket looked up from his notepad for the first time since he had started writing, and he was very still. Pruitt did not answer immediately. 1 second, 2, 3. That, he said, was a routine administrative correction, a clerical adjustment to the property description, standard practice in complex real estate filings. His voice was controlled, but it was a half step higher than it had been all morning. Destiny did not move. She did not look at the gallery. She did not look at her sister. She kept her eyes on Pruitt, and she spoke in the same level, unhurried voice she had used for every word she had said in that room. "Your Honor, I'd like to enter Exhibit C." She returned to the table. Diamond slid the documents across without being asked. Destiny carried them to the bench and set them down carefully. Exhibit C consists of 2 items. The first is the court's own electronic filing log, showing an amended deed submitted by Mr. Pruitt through the attorney portal at 6:02 a.m. today, before this courthouse opened to the public. She set the printout down. The second is a side-by-side comparison of the original deed and the amended version. She turned back to face the room. The amendment changes 2 things: the recorded acreage from 4.2 acres to 3.9 acres, and the parcel identification number in the property description. She paused. These are not clerical details. The acreage figure and the parcel ID are the foundational identifiers of the specific property being claimed. They are the numbers the court uses to locate this land in the parish record system. They are the numbers that have to match the county survey on file since 1961. She looked at Fontenot. The original deed did not match those records. The amendment makes them match. That is not a clerical correction. That is a substantive revision made the morning the document was going to be examined. The room was absolutely still. If this deed were genuine, if Raymond Arthur Tate had actually signed it in April of 2022, those numbers would have been correct from the beginning. They would have matched the parish records because a real transaction involves a real survey and a real parcel ID verified before the document is drafted. Her voice remained even. Mr. Pruitt amended this deed at 6 o'clock this morning because he knew the original would not survive today. He did not expect anyone to pull the notary records. He did not expect anyone to find the hospital admission dates. He did not expect anyone to check the filing log. She looked at Pruitt one final time. He did not expect us. Pruitt stood. His face had gone dark from the collar upward, the color rising visibly above his shirt. I will not sit here and be cross-examined by 2 uneducated kids who have spent 3 weeks playing lawyer on a home computer. This is an outrage. This is... Mr. Pruitt. Fontenot's voice cut the room clean. Sit down. I have asked you once to answer the question. I am asking you once more. Why was the deed amended this morning? Pruitt stood at the plaintiff's table with his mouth open. 31 years. 31 years of Calhoun Parish courtrooms, and Lawrence Pruitt stood in the silence of courtroom 4, with his mouth open and nothing coming out of it. His associates were both looking at the table. The man in the dark green jacket was writing steadily, his pen moving without pause. And in the gallery, Raymond Arthur Tate, 78 years old, oxygen tube under his nose, hands folded in his lap, watched Lawrence Pruitt find out what it feels like to have no answer for the room. Fontenot picked up her pen. Judge Fontenot did not speak immediately. She looked at the documents on her bench. The deed, the amended filing, the hospital records. the notary database printout with Carol Ann Pruitt's name, and the malpractice exhibit showing her admission date. 4 documents laid out in a row, the way you lay out the pieces of something after it has already broken, and you are simply deciding what to call the damage. She wrote something on her notepad. One of Pruitt's associates leaned slightly forward, then stopped himself. The ceiling fan above the bench turned in its slow, indifferent circle. Fontenot put down her pen. She folded her hands. "I've heard enough." 3 words. The room absorbed them the way dry ground absorbs the first rain after a long summer immediately, completely, without any left over. This court finds that the deed transfer presented by Calhoun Development Partners is void on 3 independent grounds. Her voice was measured and final, the voice of a woman who understood that some rulings are larger than the case they settle. First, the signature on the deed was produced by the dominant right hand of a man who has been permanently and completely paralyzed in that hand since July of 2021. The deed is dated April of 2022. The medical record is unambiguous and has not been credibly contested. Pruitt was motionless. Second, the notarization was performed, or rather purportedly performed, by an individual who was in a medically induced coma on the date the seal appears on the document. Under Louisiana Revised Statute 3514, this notarization is void as a matter of law. It is not voidable. It is void. The deed, therefore, lacks valid notarization, which is a prerequisite for an authentic act of transfer under Louisiana Civil Code, Article 2440. This ground alone is sufficient to invalidate the deed entirely. Calvin Webb exhaled through his nose, slow and controlled like a man who has been holding something in for a long time. Third, the plaintiff's counsel filed a substantive amendment to the deed at 6:02 this morning, 2 hours before this hearing. The amendment corrected the recorded acreage and the parcel identification number, the foundational identifiers of the property being claimed. A genuine deed does not require its foundational identifiers to be corrected on the morning it is to be examined by the court. This amendment does not clarify the record. It undermines the plaintiff's own claim of authenticity in a manner that this court cannot ignore. She looked directly at Lawrence Pruitt. He did not look away, but something behind his eyes had changed. The certainty that had been there all morning, that comfortable, practiced certainty of a man who has never been told no in this building, was gone. The case is dismissed with prejudice. Raymond Arthur Tate retains full and undisputed title to 4.2 acres on Pinewood Road, Calhoun Parish, Louisiana, as recorded in the parish clerk's office since 1961. She paused. Furthermore, this court is referring this matter to the Louisiana State Bar Association and to the Office of the State Attorney General for investigation into potential fraud upon the court, fabrication of evidence, and professional misconduct by counsel for the plaintiff. This referral includes the conduct of the notary of record and the circumstances of the last-minute filing amendment made this morning. She looked at the associate who had approached Diamond in the hallway. The court is also noting for the record an alleged communication made to the respondent during recess, the details of which have been provided to this court in writing. That matter will be included in the referral. The gavel came down. One sound. Sharp, clean final. It echoed off the water-stained ceiling tiles and the old wooden walls and the flickering fluorescent light in the back corner, and it landed in the chest of every person sitting in that room like something they had been waiting a long time to feel. For 1 full second, nobody moved. Then Calvin Webb stood up. He did it slowly, the way a 67-year-old man with bad knees stands when something is worth the pain. He brought his hands together once, then again. The woman beside him stood. then the man behind her. Then the rest of the second row, quietly, not dramatically. A small room, maybe 15 people. But the sound they made filled every corner of courtroom 4 and went out into the hallway and didn't stop. Destiny stood at the defendant's table and did not move for a moment. She felt Diamond's hand close around her arm. They turned around. Raymond was weeping. Not loudly, quietly, the way a man weeps when he is too relieved to hold it back and too proud to make a sound. His left hand was pressed against his chest over the pocket of his good shirt, the one he had pressed himself that morning because he had wanted to look right for whatever happened. His right hand rested in his lap, motionless, the way it always rested. Destiny went to him first. She knelt beside his wheelchair and put her hand over his left hand. Diamond knelt on the other side. The three of them stayed like that for a long moment, while the room around them slowly came back to life. Lawrence Pruitt packed his briefcase without looking at the bench, the gallery, or Raymond. His associates followed him to the side door with their heads down. In the hallway, he passed Calvin Webb, who had stepped out ahead of the others. Calvin said nothing. He simply looked at Pruitt, with 67 years of Pinewood Road in his eyes, every family that had sold cheap, every deed that had been questioned. Every morning he had watched another neighbor load their furniture into a truck, and Pruitt kept walking without meeting his gaze. That was enough. The man in the dark green jacket waited until the gallery had nearly emptied. Then he stood, straightened his jacket, and walked to the defendant's table. He was Thomas Arsenault, investigative reporter for the Louisiana Advocate. He had come that morning to observe an unrelated commercial zoning hearing on the same docket. He had stayed for all of this. His story ran 3 days later, above the fold. It named Lawrence Pruitt Calhoun Development Partners, Carol Ann Pruitt, and the 4 families who had lost their Pinewood Road properties in the 3 years prior. By the end of the week, it had been picked up by 2 national outlets. 8 months later, Destiny and Diamond Tate began their first semester at Southern University Law Center in Baton Rouge on full scholarships funded by the Louisiana Bar Foundation. Patricia Hendricks, Southeast Regional Director of the Equal Justice Initiative, had made the call herself after reading Arsenault's story. Destiny still carries the blue composition notebook. Both of them are full now. She bought a third one the week classes started, same brand, same size, from the same dollar store on Route 12. Diamond declared a double concentration in constitutional law and civil rights litigation. Her faculty advisor told her it was ambitious for a first-year student. Diamond told him she had already won a case. He did not ask again. Back on Pinewood Road, the White House with the east-facing kitchen window is still standing. The tomato garden is still there, tended now by Calvin Webb, on the days Raymond's knees won't allow it. Raymond still sits on the front porch every evening, with his coffee going cold in his left hand, watching the pine trees do what they have done for 60 years. 3 other families contacted Destiny within a month of the hearing. 2 of them had deeds bearing Carol Ann Pruitt's notary stamp on dates that fell within her hospital stay. Those cases are pending. Lawrence Pruitt's law license was suspended pending the bar investigation. Calhoun Development Partners quietly withdrew every remaining land claim in the parish. Brent Calloway, CDP's principal investor, has not been seen at the Calhoun Parish Courthouse since. And on Pinewood Road, for the first time in 3 years, nobody is leaving. Raymond Tate didn't save his land with money or connections or a powerful name. He saved it because 60 years ago he planted something deeper than tomatoes on that soil. He planted the belief that what is yours is worth defending. Destiny and Diamond didn't walk into that courtroom with credentials. They walked in with preparation, with each other, and with the truth. That has always been enough. If this story moved, you don't just watch it alone, share it with someone who's been told they don't belong in the room. Drop a comment telling me what part hit hardest. And if you're not subscribed yet, this is the story that should change that.